Hello, everyone. My name is Stephen Brown. I'm Executive Director of the ACLU of Rhode Island. I want to thank you for joining us for our annual review of some of the major civil liberties decisions that the U.S. Supreme Court issued in its most recent term. It was actually quite a momentous term, and we're happy to have some experts here tonight to explain some of the highlights and some of the lowlights to us. Just a very few brief housekeeping items before we start. The event is being recorded in case you want to encourage friends and colleagues to watch it later. We'll be posting it in the near future. Don't worry, though, we can't see any of you. You aren't going to appear on the screen at all. Also want to make you aware of the Q&A box. It's at the bottom of your screen. Don't confuse it with the chat box. It just says Q&A, and if you click that at any point, you can submit a question to our panelists. We're going to wait till the end of all the comments by the panelists so that we can get through all the cases first, but we are going to leave some time for Q&A at the end, so I hope you'll feel free to submit questions as the event moves along. I also want to thank the ACLU staff, Zoe Chikoyan, Monica Smith, and Megan Kachadorian, who've been working behind the scenes to make this happen. So to get right into it, I want to read a quote from David Cole, who's the National ACLU's legal director, in an article he wrote summing up the term. And he began the article by saying this, and I quote, "The Supreme Court in its just concluded term extended substantial new rights to hedge fund managers, big business, and former President Donald Trump, while denying constitutional protection to homeless people punished for sleeping in public, Black voters in South Carolina, and an American citizen whose non-citizen husband was denied a visa without explanation. This is perverse. We give unelected courts the power they have so they can defend the rights of those who cannot protect themselves through the political process. Yet the court flipped the script this term, consistently doing the bidding of the powerful while turning away the claims of the powerless. And it did so in its most consequential cases by the same 6-3 vote, with justices imposing their will less by law than by sheer force of numbers," close quote. I think that's an accurate, if unfortunate, explanation. We'll be reviewing only a few of the cases that David has alluded to in that quote. We've also made an effort to try to include some of this year's civil liberties victories, because there were a few, although, as I think you'll hear, the long-term nature of these victories remains to be seen. But I don't think it can be denied that this term marked a turning point where the so-called conservatives on the court seem to be on a sprint to redefine the law in a lot of ways that could be seriously detrimental to civil rights and civil liberties. But on that sort of uncheery note, let me introduce you in alphabetical order to our very distinguished panel of experts, and then we're going to get right into the cases we're going to cover. The first is David Cass, who's an ACLU cooperating attorney. He's been practicing law for more than 20 years in Massachusetts and Rhode Island courts. His practice includes representation in a wide range of fields, including family law, employment law, and unfair and deceptive trade practices. We also have a trio of experts from Roger Williams University School of Law. Jared Goldstein has been a professor of law there since 2005, where he teaches constitutional law. He previously worked in the U.S. Department of Justice and later represented detainees held at Guantanamo Bay. He's authored numerous briefs in the U.S. Supreme Court, and starting this fall, he'll be directing a new prisoner rights law clinic at the law school. Deborah Gonzalez is the director of the Immigration Law Clinic at the law school. She was previously in private practice, where she represented immigration clients in a wide array of cases, and she currently serves on the ACLU of Rhode Island's board of directors. Diana Hassel has been a member of the faculty at the law school since 1995. She teaches in the areas of constitutional law, civil rights litigation, and lawyering skills. She received her law degree from Rutgers Law School and a BA from Mount Holyoke College. Lynette Labinger is a longtime ACLU of Rhode Island cooperating attorney and a very well-known civil rights lawyer who, over the course of a few decades, has successfully litigated numerous challenges to state anti-abortion laws, among many other civil rights legal victories. And last but certainly not least is Jennifer Wood, She's the executive director of the Rhode Island Center for Justice, a nonprofit public interest law center that partners with community groups to strengthen existing advocacy and legal representation on some of the most pressing issues affecting low-income people in our state. She has over 30 years of public interest experience in a variety of roles. So as you can tell, we have a great and very knowledgeable array of panelists, and we're going to get right into it now. The first case we're going to discuss was probably the most anticipated of the term, and in my view, the most stunning in terms of its scope and its ramifications, and that's Trump versus United States. And to discuss that tonight is Jared Goldstein. Jared?
Good evening, everyone. I hope you're all doing well. I'm so glad that you were able to show up for this event. Most of you have probably heard at least the headline level news about Trump versus United States. In that case, the court addressed a question that it had never before been called on to answer, which was whether a former president can be prosecuted for crimes they committed while in office. Now, the text of the Constitution does not include any sort of prohibition on prosecuting former presidents. Instead, what it says is that a president or any other federal office holder who's been impeached and removed from office shall nevertheless be liable and subject to indictment, trial, judgment, and punishment, according to the law. So the text makes clear that a former president can be prosecuted. The framers of the Constitution also made clear that they believed that former presidents were subject to prosecution. Hamilton says in Federalist 69 that unlike a king, the president would be liable to be impeached, removed from office, and would afterwards be liable to prosecution and punishment. So you might think that if you were a textualist or an originalist, that this would be an easy case to say that a president is subject to prosecution after being in office, and the Constitution contains no constraints on that. Well, if you thought that, you would be wrong. Because the court in Trump versus the United States held by a 6-3 vote that President Trump and all subsequent presidents are immune from prosecution for most crimes that they commit while in office. In an opinion by Chief Justice Roberts, the court created a very complicated test for determining which acts are entitled to immunity. In particular, the court said that presidents are absolutely immune when they're exercising what can be described as their core constitutional authorities. They are presumptively immune from prosecution for any other official act, and they have no immunity for private or non-official acts. Now, as I said, the text doesn't say anything to impose any limit like that, and the framers of the Constitution or anyone at the time of the framing the Constitution wouldn't have thought that there were limits on prosecution like that, or at least there was no evidence that anyone believed it. But instead, the court based the decision on separation of powers principles. What the court saw as the need to protect the president from worrying that the courts would second guess their actions or that Congress could punish the president for his actions. So if the president had to worry about interference from these branches, the court said, he might be distracted and might not put the needs of the country first. The court also looked at some precedent that it thought mattered. The court had previously found that a president was absolutely immune from civil liability, that is liability for damages in a private lawsuit for his official acts. And the court thought that criminally prosecuting a president was even more of an intrusion on the president's decision-making than civil liability. So, of course, the court thought that the president must be immune from criminal liability as well. But to really understand what the decision means, you have to parse some of the key terms that the court used. As I said, the court ruled that the president is absolutely immune for exercising his core constitutional powers, is presumptively immune for all other official powers or official acts, and not immune for private acts. The court then applied these principles to the Trump indictment and found that some of the indictment, this was the indictment over the January 6th interference with the election case brought by the special prosecutor. And the court said some of the allegations involved the president's core constitutional powers for which he's absolutely immune. In particular, the indictment alleged that the president had acted with the attorney general to undertake sham investigations into non-existent election fraud and threatened to fire the attorney general if he refused. The court said that as head of the executive branch, the president's core powers include deciding what alleged crime should be investigated and whether to fire executive branch officials. And so therefore, no court could examine the validity of the president's actions in these areas, regardless of whether the president was using those powers illegally. Then the court looked at some of the other allegations, like the fraudulent electors allegation, and said that here the president was presumptively immune because most things that the president does must be official acts. And so the court remanded the issue to the lower courts to see if the prosecutor could overcome this presumption. Then the court looked at what the president did on January 6th by inspiring the crowd to go and invade the Capitol to try and interfere with the election certification. And the court said, well, presumptively, that was an official act too, because the president has broad powers to speak with the public about issues of public policy. But maybe there's some possibility that he was acting as a private person when he made this speech. So it remanded the case to the lower court to decide that too. So that's essentially the gist of the decision. There's a lot more to it, and I could go on, but I only have about a minute and 30 seconds left in my allotted time. So let me just say a few things. So clearly the case has immediate impact on the 3 pending indictments of President Trump and his conviction in state court, because the court says that before the president can be indicted in any of these matters, it has to be determined whether the acts that are alleged were his official acts or his unofficial acts. And so all those cases now have to grind to a halt while someone parses them to decide if what's alleged are acts for which the president is immune. And again, the court says presumptively everything the president does, he is immune from prosecution for. Now, but beyond these immediate implications, there are long-term implications. Dissenting Justice Sotomayor says that the decision means the president is now above the law, that the president can do almost anything, no matter how criminal, without fear of prosecution. And she fears that future presidents will now know no limits, or at least no legal limits on their power. And she might be right. It's possible that future presidents will feel emboldened to commit crimes without fear of consequences. It doesn't seem very far-fetched with President Trump and possibly others. Now, for me, I agree with all those concerns, but I have to be honest, I think there were very few legal constraints on what a president could do before the decision. That is, the president can launch wars, assassinate foreign leaders, largely ignore federal law without fear of any personal repercussions. Courts have some limited power to order a president to stop, and Congress has some power to require a president to act or to stop acting. And these powers continue to exist, and that hasn't changed. But it's pretty rare and unlikely for these branches before the decision or afterwards to interfere with what the president does. So the president was largely unconstrained by law before the decision. It's now just become more stark that that's the case. I think it makes even more stark than ever that politics is the only truly effective constraint on presidential power. That we shouldn't expect the courts or Congress to protect us from a tyrannical or despotic president, and that only the people as a whole acting through the political process have any power, if we have any, to stop the president from acting in a tyrannical way. And with that, I'll turn it over to our next presenter. I look forward to answering any questions if you have.
Thank you very much, Jared, and thanks especially for giving the context of what this means for the future. I think that's very important. Our next presenter is Lynette Labinger, who's going to talk about 2 abortion decisions that the Supreme Court sort of decided, and she'll explain exactly what that means. Lynette?
Okay. I noticed that it's listed on your screen as a temporary civil liberties victory. But the reality is, from the court's perspective, it's not a civil liberties case at all. Why? Because in 2022, in Dobbs, the court rejected the notion that reproductive rights are civil liberties rights. So we've lost those. Technically, it was an Administrative Procedures Act regulatory case, but obviously had major implications for reproductive freedom nationally. So I'm going to take a running start. Back in 2000, that's 24 years ago, the FDA approved a new drug application for an abortion-inducing drug called mifepristone or mifepreps. It's worth noting that this drug had been approved in France as early as 1988, so a good 12 years earlier, and then a whole bunch of factors and abortion influences, legislation, so forth, kept it off the US market until 2000. And when it was approved in 2000, it was only approved for use up to 7 weeks, which we're all very aware now is really barely after people realize they might be pregnant. And it required several in-person visits to the doctors, all of which limited accessibility. Over time, the FDA modified its approval. And by the time that this suit that we're talking about here was brought in the year 2022, mifepristone was authorized for use up to 10 weeks, no longer required any in-person visit, and expanded those who could prescribe it from just doctors to nurse practitioners. Now, you may recall a few years earlier, before Dobbs was decided, Texas had passed this law called SB 8, which was essentially created a bounty system, allowing anyone to sue any person believed to have assisted or facilitated an abortion in Texas or by a Texas resident. And the Supreme Court's response, this is again before Dobbs, when abortion in theory was still protected under Roe versus Wade, essentially saying that no federal court could stop the enforcement, leaving it as the Wild West, so to speak. So between that action and the Dobbs decision in 2022, which said there is no constitutional right to an abortion, it appeared to be open season in the US Supreme Court for anyone trying to get an abortion, and open season against enforcing those rights. In this case, it was brought in 2022, which is called the FDA versus Alliance for Hippocratic Medicine, a national association of physicians providing pregnancy-related health care, but not abortions, and certain named individual physicians providing the same, brought suit against the FDA to challenge the original approval back in 2000, as well as those subsequent regulations which expanded the availability of mifepristone. The pharmaceutical company which had obtained the approvals also intervened to defend its approvals. The suit was brought in the Northern District of Texas before a very friendly judge. He ruled completely in favor of the plaintiffs and granted a nationwide preliminary injunction prohibiting the original approval in 2000 and all post-approval decisions of the FDA. If that decision had gone into effect, then no one could market mifepristone anywhere. His reasoning was that the original approval was flawed and that the expansions were without authority. This was all regulatory issues under the Administrative Procedures Act, which I said it's not really technically a civil liberties case. The FDA and the pharmaceutical company appealed to the Fifth Circuit, which stayed a portion of the injunction so that the original 2000 approval was not undermined, but refused to stay the rest. Later ruled that the plaintiffs had waited too long to challenge the 2000 original approval, but were correct about the expansions and enjoined those. In the meantime, the Supreme Court had issued a stay of the entire injunction while the Fifth Circuit was deciding, and if it was appealed to the Supreme Court, and until the Supreme Court completed its review or declined to review. Meaning that, in fact, although there were these horrible decisions and a very draconian acts hanging over access to medication abortions, there was no change in the status quo until the Supreme Court finished its review, which happened on June 13, 2024, when the Supreme Court, in a 9-0 decision, reversed both the Fifth Circuit and the District Court, eliminating the preliminary injunction, but not totally throwing out the case. There's still a piece of the case pending. From an outcome basis, this was a great outcome. and there are currently no court decisions restricting FDA approval of mifepristone from 2000 or the current regs from 2016 and 19. But from a where do we go next standpoint, it's not such good news, as the case was decided not on the basis that the FDA was correct in any of its approvals, but rather that the physicians and their organization did not have the necessary standing, that is, a legally recognizable stake in the outcome to challenge the decisions. It's a good decision. It put a brake on the most extreme approach of the Texas trial judge in the Fifth Circuit, who all bought the plaintiff standing argument, which was basically, it was against their conscience to have anything to do with abortions, and depending on what happened to somebody who accessed a medication abortion, if everything went wrong and these people showed up at their hospitals and nobody else was available to treat them, they may have to act against their conscience. It was very, very convoluted. The Supreme Court said no, it was too speculative, it had never happened, and they weren't going to allow these doctors in the organization to basically manufacture standing in order to challenge these regulations. But that doesn't necessarily mean that some other creative plaintiff might come forward in the future and try this all again. And I welcome your questions when we get to the end. Thanks.
Thank you, Lynette, for, again, the sort of disheartening nature of this victory. I do want to remind people before we go on to the next cases that please use the Q&A if you have any questions at all, so we can get to answer any questions you might have once the comments are done. Next is Diana Hassel, who will be talking about two social media decisions that the Supreme Court issued that, again, at least on their face, are good decisions, but they left some things back for the lower courts to decide, so things still remain a little bit up in the air, and we'll have Diana explain it. Diana?
Yeah, hi, good evening, everybody. Thanks for listening. Yeah, so this is another kind of kicking the ball down the road, if that's the expression, kicking something down the road, and seems promising, but it's not clear yet how the court will ultimately come out. So in these net choice cases, what happened is after 2021, both Texas and Florida passed laws. They were concerned about their perception that social media platforms such as Facebook and YouTube were limiting the conservative speech. They were particularly concerned about President Trump being removed from, I guess, Facebook or Twitter or whatever he was removed from, and they wanted the platforms to have limited ability to make content-based decisions about what was on their platforms. So both states passed laws. There were some differences, but pretty similar laws that required the lessening of any moderation by these large social media platforms. They were not allowed to block content based on views, and if they did block any content, they had to give an individualized explanation to the person or the company or whatever that was blocked as to why they did it. And so it was really going to make it very difficult for these large platforms to do what they normally do, which is a tremendous amount of, through algorithms and other techniques, organizing, moderating, labeling, all the kind of content that we see on things like Facebook. So, of course, through an organization, a trade organization, Net Choice, these statutes were challenged, came up through the Fifth Circuit and the 11th Circuit, and then eventually got to the Supreme Court. So the challenge to these laws was on its face, which means the plaintiff is saying that this statute is unconstitutional across the board, not just with respect to us, particular plaintiff, but with respect to anyone. And so they wanted the statute struck down in its entirety as on its face unconstitutional. And the court's major decision, and a decision written by Justice Kagan, It's a 9-0 decision, though there were many concurrences with, slightly different approaches, said that, well, wait a minute, in order to have an on-your-face, a facial challenge based on the First Amendment, the court has to make some assumption, do some fact-finding, do some legal analysis first, which the lower courts didn't do. In order to challenge a First Amendment challenge, the lower court has to decide that the statute would be substantially unconstitutional. That means for most of its applications, for most of the possible defendants, it would be unconstitutional. And maybe there's a few people who conceivably their constitutional rights would be violated, but that's okay. It's substantially unconstitutional. And the Supreme Court said, well, the lower court didn't do any of this work. They just talked about the Facebook, YouTube, the big, huge platforms, but the law is written in such a broad way, it could apply to things like Uber and Etsy and Venmo and email providers and direct messaging and all this kind of stuff. And so maybe the law is constitutional with respect to them, even though it might not be constitutional with respect to Facebook. So we're sending it back down. Do this analysis about how much of the possible application of this law would be unconstitutional. But then Justice Kagan went on to say, but we noticed that the 11th Circuit, who had upheld the statute, the Fifth Circuit that had upheld the statute, got their analysis all wrong. The Fifth Circuit had said they didn't think the moderating activity that these platforms did was even protected speech at all, and that even if it was, the government had a substantial enough interest in providing a balanced viewpoints in the marketplace of ideas. And Justice Kagan rather ruthlessly said that this was completely wrong. This was a misinterpretation of precedent and doctrine on the First Amendment, and Fifth Circuit, don't do this again when we send it back to you. So she said the question is what these platforms do in deciding what order the news feed's going to come in, what things they're not going to allow. They have these community standards things which attempt to eliminate hate speech and things promoting crime and other things they find offensive. So they're doing a lot of moderating and they're doing a lot of controlling. And is this expression and therefore protected by the First Amendment? And Justice Kagan said, obviously it is. It's just like a newspaper that's deciding what articles to put in, what articles to put out. We don't have a general, the government doesn't have a general ability to tell the newspaper what to put in. It's on its pages because that would be a violation of its First Amendment rights. Very baseline principle of First Amendment law is the government can't interfere with private speech. And so by trying to tell these platforms that, oh, you shouldn't include this, you must include that, is interfering with core expression. And therefore, for platforms such as Facebook and YouTube, which are large collections of third-party speech, this would be a interference with their First Amendment rights. But of course, as we know with all rights, they can be interfered with if the government has a good enough reason, right? And so the reason put forward by the states of Texas and Florida was we want to balance the marketplace ideas, promote a greater variety of expression. That's the government interest in doing that. And Justice Kagan says, oh, that's exactly what the government can't do. The marketplace of ideas is supposed to be free from government interference. That's sort of the point. And here the government is trying to control that speech. Big no-no, can't do it. Now, of course, the states had argued that this activity of moderating isn't really speech at all. It's just sort of collecting material. It's not expressive activity. Therefore, the First Amendment doesn't apply. And if it does apply, it's important enough interest of the government to sort of maintain some kind of balance of views. Justice Kagan made it very clear for big social media platforms, that absolutely didn't work. Whether it would be possible to make those kinds of arguments for other different kinds of social media platforms, such as direct messaging, etc., maybe. That's why it has to be vacated back to the lower courts. Now, there are many, well, a few concurrences. Justices Thomas and Alito agreed with vacating the cases and setting them back, because this analysis of how much of the application of this law would be unconstitutional, but were quite critical of Kagan's First Amendment analysis and said it's nothing but dicta, and were quite more sympathetic with the Fifth Circuit's conclusions that this wasn't speech and the government has a legitimate interest in controlling what goes on social media. So when it cuts back to the Supreme Court, it does look like the majority is going to say, for most big social media platforms, this law is unconstitutional. There might be some outlier applications that it would apply to, but all of the decisions talked about, there's a lot of concern now about regulation of social media. There's Child Protection Act that's kicking around in Congress. There's legitimacy of Section 230, which protects social media platforms for any liability for any content on their platforms. And so this whole issue is sort of related, and sort of asked Congress to sort of make some rules about what's appropriate regulation, what isn't, but anticipate that this will be coming back in various forms in the next, several years. So a good sign that likely this kind of government control of social media will fail, but not, there's certainly some on the Supreme Court who would disagree with that.
Thank you, Diana, for another to be continued series of cases. We're seeing a trend here. But speaking of social media, our next case that we're going to talk about also involves social media. And it's a case that David Cass, who'll be talking about it, knows a lot about, because he actually handled a case for us on this issue. And David, take it away.
Hello, all, and thank you, everybody, for being involved in this organization and being part of this. So the last section was about the larger scale implications of social media and regulation of social media. The cases that I'm going to be talking about, Linkey versus Freed and O'Connor-Ratcliffe versus Garnier, are more about the small individual application of social media and the effect that blocking and editing social media responses by government officials can have on a public forum. A little background: the case that Steve talked about is a few years ago. We had a case against the city of Woonsocket. The mayor had banned and blocked and then banned a couple constituents based on their negative view of some of her actions. And we were lucky enough, after filing suit, to be able to resolve it positively for the two constituents. But the standard that we employed back then was a standard having to do with what's a public forum. And once a government official establishes a public forum, once you engage in that, now you're kind of limited. You can't start blocking. You can't engage in viewpoint discrimination. You can't block views or discussion that you don't like or that's negative towards your position. Along comes the cases that we're dealing with tonight, Linkey versus Freed and O'Connor-Ratcliffe versus Garnier, and they deal with it exactly in a different way. So there was a split in the circuits. The more what I would call progressive or liberal circuits looked at social media postings by a government official in a more holistic concept, meaning if you were a government official and you were engaging in discussion with your constituents, you were creating a forum, a public forum, to engage your constituents. And once you got to that point, you couldn't engage in the viewpoint discrimination. Now, to get to that point, you had to show that there was some nexus between the position the person held and the discussions that were going on the forum. And that was a fairly amorphous and open dialogue, and it allowed people who had been blocked a lot of avenue to go in and try and have that resolved to their benefit. Along comes, let's call it the main case here, which is Linke versus Freed, where a city manager for a city in Michigan has a personal Facebook page before he becomes the city manager, posts usual independent stuff, family, pets, other things, becomes a city manager and starts engaging in posting information regarding his position with the city. Now, he engages in disseminating information, providing information about services, and specifically about the reaction or the implementation of COVID restrictions and how the city was handling COVID. A couple of constituents were less than enthused with Mr. Freed's position on COVID and the way the city was handling it, and made their position well known on these social media feeds, mainly Facebook. The issue, so Mr. Freed decided that he didn't want to engage in that kind of discussion, and initially started editing out responses, and then eventually blocked the two individuals and removed them from their ability. For those of you, I assume that all of you are familiar with social media. The concept of editing posts and blocking have two different effects. Editing posts means you take away the immediate information and the responses in that post. Blocking bans the constituent from having any engagement on the forum and limits their ability to not only post on that one issue, but on any issue that's brought up on the forum. The district court in that case in Michigan ruled against the constituent, ruling in essence that Mr. Freed was not acting under color of state law. So a little background here, under the 1983 claims, which is what these claims are, the official has to be acting under the color of state law in order to achieve some form of liability. The issue about whether acting under state law is the main issue that when I discussed earlier about whether or not it's part of a public forum, how you get to that forum, how do you get to that analysis? The district court determined that Mr. Freed, since he had a personal Facebook page and his social media was personal, that regardless of what he put on there to some degree, since it was personal, there was no liability because he wasn't acting under the color of state law. The Sixth Circuit agreed, and the constituents appealed up to the Supreme Court. The Supreme Court, Justice Barrett writing for everybody, which was the disappointing part, that there was no dissent and nobody that was fighting against this, what I would call very narrow view of viewpoint discrimination in social media, determined that in order for there to be a claim by a constituent, you had to satisfy the main two principles. One, that the official possessed the actual authority to speak on the state's behalf, and two, purported to exercise that authority when that person spoke on social media. And what Justice Barrett did in analyzing this is broke it down into the most obvious analogy that she used was someone who is working for a town can put something out, can involve a city website and put out information, but when they go to a barbecue and talk about it, they're not acting under the color of state law. And she likened that any personal Facebook post to be like that backyard barbecue more so than it is an official government access point for constituents. What I would say from my personal opinion is this, is that it views social media as a one size fits all when it comes to municipal engagement or government engagement. Small towns have very limited social media presences, and so any official can have a personal Facebook page and can put information out. As long as it's considered personal, you get around the restriction on viewpoint discrimination. The only way to really fight that back is the kind of very, very narrow target that the court maintained. If you can establish that in a personal Facebook page, that the person has the authority, meaning their job is to engage in informing the public or soliciting viewpoint or participation by the constituents, then you've gotten halfway there. Once you do that, you then have to show that the comment or the statement that was being commented on by the constituent is then within the realm to which that official's duties apply. Again, I think the issue there is, say someone works on the tax board and they're making comments about COVID restrictions. If they were making comments about the tax board, maybe you have a claim, since they're making comments about COVID or dissemination of information, that's outside of their job description. And I think that was one of the key phrases here, is the concept of job description, which for most public officials doesn't really exist. But anyway, we're supposed to intuit that as part of what Justice Barrett says is the inquiry. Once you get those two things, you get in essence, the authority to offer information or to engage in the social media back and forth with your constituents. And then you get acting within that authority. Then you can get into the point where viewpoint discrimination is no longer valid. What that does is it takes it away from analyzing the form as a general concept to analyzing individual posts. So now you can have a post in a personal Facebook, if it's from a high-ranking town official that makes a statement regarding the implementation of an emergency act or something like that, and there's comment on that you may have a claim for under 1983 for a violation of your rights there. That's a very, very, very narrow application compared to what we had seen, especially in the First and Second Circuit over the years. So what this does, again, and what it does is it makes it so it almost eliminates, I think, cases that can be brought against non-executive branch administrative or officials. You going after a senator or a congressperson, either state or federal, they're not in the position to have a job duty that enshrines them or encases them under state law so that they can provide, so that you can't get the foothold to hold them liable. The issue that we had in the Woonsocket case was he was the mayor, so we had the executive action, we had the statements. So I do think that case, I'd like to think that it would have survived under this standard, but it is a much more rigorous and much harder bullseye to hit, which will reduce and limit the ability of constituents to fight back and maintain their voice on social media. And I look forward to any questions you might have at the end of this.
Thank you, David, for that summary. Thank you for your good work in the Woonsocket case, and let's hope there will be other opportunities to challenge, even with this fairly limited decision of the Supreme Court, but to challenge other censorship by public officials in Rhode Island, because I think it's an issue that affects a lot of people who want to be able to use social media to answer the comments that public officials themselves make on those media. Moving on to, this was a bad year for civil liberties in the Supreme Court. We're going to now discuss, I think, what was one of the most cruel decisions of the court this term. And Jennifer Wood, who has a lot of expertise and works day in and day out on housing issues, will explain it to us. Jennifer?
Well, I guess whether it's one of the most cruel decisions would depend upon your definition of cruel, which comes into play in this case, Steve. Good evening. I'm going to talk for a few minutes about the case Grants Pass, Oregon versus Gloria Johnson. And this case is a little bit different from some of the other recent Supreme Court decisions that have been discussed tonight and have been widely discussed during this Supreme Court session, in that it doesn't directly upset longstanding precedent and legal frameworks, but very sadly, this case did reject a decision from the Oregon District Court and the Ninth Circuit Court of Appeals that would have protected homeless people across the nation from having their conduct of sleeping outdoors, living in encampments, criminalized and punished. And many of us who are working in the area of housing and homelessness were very optimistic when Grants Pass was decided in the Ninth Circuit that it might begin to be something that could be used to push back against the cruel disestablishment of outdoor sleeping, homeless encampments that people are forced into by necessity often. But those hopes were dashed with the issuance of this decision. 3 people who were living in their cars in the city of Grants Pass, Oregon, brought this case under the theory that ordinances that criminalize sleeping in public and in cars violate the Eighth Amendment prohibition on cruel and unusual punishment when they have nowhere else to sleep. The plaintiffs relied on two cases. One, Martin versus Boise, which was a 2019 Ninth Circuit decision, and an older case from 1962, Robinson versus California, which I'll talk about later, but which laid some of the groundwork for why it could be argued that it's cruel and unusual to criminally punish folks who are sleeping outdoors when they have nowhere else to go. In 2019, the Ninth Circuit in that Martin case overturned a Boise ordinance which criminalized public camping. And that was overturned on the basis that Boise did not have adequate shelter resources for the homeless population in the city. And the Ninth Circuit deemed it cruel and unusual to punish people criminally when there are not enough shelter beds to house the people who are unhoused in the city. Sadly, in the Supreme Court decision, writing for the majority, Justice Gorsuch referred to that Martin case overturning the Boise ordinance as, quote, a failed experiment, and stated that the Grants Pass ordinance against public camping did not violate the Eighth Amendment because, first of all, the Eighth Amendment is not about whether something can be criminalized, whether particular conduct can be criminalized, but rather is about the nature of the punishment, not what is being punished. Secondly, the Supreme Court relied upon the fact that the punishments in the Grants Pass ordinance were, in a sense, escalating, starting with civil fines and then ramping up to an ultimate punishment of incarceration for up to 30 days for a second or third offense. And also, the court rejected what it dismissively referred to as the Ninth Circuit's use of back of the envelope math in relying upon the fact that when there are more homeless people in an environment than there are shelter beds, that is by its definition cruel and unusual if you then criminalize the conduct of these people who are involuntarily forced into sleeping outdoors. So the Supreme Court rejected and overturned the decision in the Grants Pass case, but also overturned the 2019 Martin decision, taking those off the table as protections for homeless people. Had the decision gone the other way, homeless individuals nationwide who were sleeping outdoors would have been able to, for the first time, have some protection from that conduct being criminalized. The Supreme Court also strongly criticized, but didn't actually overturn, an earlier decision that the plaintiffs in the Grants Pass case relied upon. In Robinson versus California in 1962, the Supreme Court ruled that it's cruel and unusual to criminalize a status rather than conduct. So the California law that was overturned in Robinson made it a crime to be addicted to narcotics, not to use or sell or possess narcotics, but to actually be addicted to narcotics. And that was deemed to be cruel and unusual. Part of the logic there was that if you criminalize the status of being an addict and lock addicts up, it is an intense mental and physical torment to go through detoxification and essentially to go through cold turkey while incarcerated. But the majority in the Supreme Court in this Grants Pass case said, well, we don't need to deal with Robinson because the Grants Pass ordinance criminalizes sleeping outdoors. It doesn't criminalize the status of being homeless. Justice Sotomayor, writing for Sotomayor, Kagan, and Jackson, said, well, that's bunk. And in fact, the Grants Pass ordinance exactly criminalized status because she looked at and really analyzed the city council's deliberations in enacting the statute, the ordinances that made it a crime to sleep outdoors, sleep in a car, to have a blanket when you're outdoors and sleeping. And the city council dialogue in enacting the ordinances made it very clear that their target was homelessness as opposed to sleeping outdoors. For example, she pointed to the city council president's statements saying that we need to make our cities so uncomfortable and painful for homeless people that they will just go elsewhere. So in looking at the dissent, we can really understand better what the majority has done in their decision in Grants Pass. I think it's very helpful to look at both the dissent and Justice Thomas's concurrence. But before I get to the concurrence, I want to point to the very harsh language in the majority's opinion upholding the Grants Pass ordinances that make it illegal to sleep outdoors in that city. The Supreme Court, in the majority opinions, redefines what is cruel, to your earlier point, Steve, and what is the meaning of cruel and unusual under the Eighth Amendment. The majority says that the ordinances criminalizing homelessness are not unusual because a majority of American cities employ ordinances of this type to prohibit public camping and implicitly to criminalize homelessness. And not only are they not unusual, but they're not cruel because, and this list is in the decision, they don't involve disembowelment, quartering, public dissection, or burning alive, thus restricting the definition to what is cruel and unusual to medieval torture, as Sotomayor points out in her dissent, and really talk a lot about penalties that cause terror, pain, or distress. So really upping the ante on what can be considered cruel, as opposed to the fundamental cruelness of punishing the status of homelessness when there are no shelter beds available. Justice Thomas, of course, always feeling his oats these days, in his concurring opinion, wanted to go beyond the majority and overturn not only the Martin case, which had overturned the Boise decision criminalizing homelessness, but also would have and argues for overturning the Robinson case, which makes it, which deems it a violation of the Eighth Amendment to criminalize the status of being, in that case, an addict. He states that the Robinson case was simply wrong and should be gone. And that because the Robinson case relied upon the notion that a law which makes having a disease a criminal offense is cruel in light of contemporary human knowledge, and that contemporary human knowledge is a quote from the Robinson case, Thomas says, quote, "Modern public opinion is not an appropriate metric for interpreting the cruel and unusual punishment clause, nor any provision of the Constitution," and argues that Robinson should be disposed of once and for all as soon as possible. So we really see here a direction in terms of the limiting the scope of the Eighth Amendment, what can be deemed cruel and unusual. Justice Sotomayor keeps coming out swinging in her dissent and points out that not only did the Grants Pass ordinance really, in its essence, criminalize status, if not in its words, the status of being homeless, but also points out that there were a number of other ways that the ordinance could be challenged, seeming to invite those challenges in the future. So happy to answer any questions, but this one was a pretty devastating blow for those of us who have to advise people who find themselves living outdoors. And sadly, instead of building on a tool that seemed to be possibly emerging for protecting people who don't have access to shelter beds and are living outdoors, takes away that prospect, at least for the time being.
Thank you, Jennifer, for that distressing summary, but I think an accurate one. Our final review of the Supreme Court term before we turn to questions is another very troubling, disturbing, and somewhat cruel decision from the court. And to discuss it is Debbie Gonzalez. Debbie?
Thanks, Steve. Thanks, everyone, for tuning in. I think this case is more of a marriage rights case disguised as an immigrants' rights case, although I think there's an intersection in both. So the State Department v. Munoz is a case regarding a husband and wife where a U.S. citizen wife petitioned for her husband for him to come to the United States to live here after having been married for 5 years. Because the husband had entered the United States without proper documents, he had to return to the home country and undergo what's called consular processing. And consular processing is done with the Department of State, the department that's in charge of effectuating immigration laws outside of the United States. After waiting for 5 years for him to get an approval of his visa petition and a waiver for the unlawful presence he had in the United States, he underwent his interview. And mind you, he and his wife lived together in the United States while they were waiting for this process. He goes for an interview and is denied his visa with no fanfare at all or even a decision, but for the officer to tell the husband, you're denied, you're not eligible for this with no reason. The U.S. citizen wife, of course, being unhappy with that decision, insisted that the Department of State give one. Unfortunately, under immigration laws, a decision in writing as to the reason why a visa is being denied, and when I say a visa, I mean lawful permanent residence, right, a green card, is being denied, is necessary only if the denial is not based on a crime or terrorist activities. And so if the decision is based on a crime of terrorist activities, then the only thing the Department of State needs to say is it's denied. Munoz, not being happy with that decision, filed in district court and claimed a liberty interest in receiving a reason for the denial. That was her issue at the district court level. District court agreed and said, we agree, you need to know why this is. And although the statute says that they don't have to give a decision because she filed in district court under a liberty interest issue, district court ordered discovery and found out that the reason why her husband had been denied was because he had certain tattoos. Now, tattoos, I guess, are permissible unless you're an immigrant, of course, in which case, if you're an immigrant, then you need to be careful what you're putting on your body. This gentleman had tattoos of the Lady Guadalupe, Sigmund Freud, a tribal pattern, and theatrical masks that had dice and cards in it. The Department of State told the district court that the reason why they denied the visa was because they believed that his tattoos were an indicia of gang membership, even though in this case, this gentleman, the husband of Ms. Munoz, had no criminal record, no connection at all to any gang membership. Once the district court received the reasoning from the Department of State, they issued summary judgment in favor of the department, because also under the Immigration Nationality Act, decisions that are made by consular officers with the Department of State are not judicially reviewable. So the fact that she even got the district court to hear this really is interesting, but I think the way she posed her question with the district court, I think, was a valid one, right? She claimed it as a liberty interest. After summary judgment, she was unhappy with that and then filed in the Ninth Circuit. And the Ninth Circuit reversed and vacated the judgment, finding that she did have a constitutionally protected liberty interest in her husband's visa, as opposed to claiming it a marriage, right? A constitutionally liberty interest in being married to her husband. And she did argue in the Ninth Circuit that they had been living together and they wanted to raise children and they wanted to have a life inside of the United States as a married couple, as she was a United States citizen, although the case didn't say whether or not she was a national or born in the country that he was from, which was El Salvador. The Department of State then petitions for cert and the Supreme Court grants it, but the Supreme Court takes this case, I think, much further than saying this is not a judicially reviewable issue, right? That the statute is clear in saying that immigration issues, particularly consular processing issues, are not reviewable by the court, and the court could have ended it there. In fact, why the court even issued cert in this case is really unclear. Although I guess they wanted to do away with these people's rights, or, you know, to even have it, because in the Ninth Circuit, when the Ninth Circuit remanded, they not only told the district court to find that she had an interest, but then to also reverse the Department of State's decision, which under the statute they don't have the right to do. And even under, you know, precedent law, there's no right for any court to issue a decision that would be reviewing an immigration decision by a consular officer unless that right was violating a constitutional right, which the Ninth Circuit here found, which was her right in her husband's visa. The Supreme Court then, you know, grants cert, and they, in the decision, was interesting that they, I think, were having a hard time to figure out what the issue was. And I think it was because they were trying to really water down the idea that someone's marriage to a foreign national really holds any weight, right? Because we believe, or so far it has been, God knows if it will continue to be, that marriage just is a fundamental right. We have a right to be married to whoever we choose. And there are several cases that back that up. Loving backs that up. Goldberfer, I think I'm saying that Goldber, yeah, okay, well, Goldberfell, I'm saying that wrong, but that's the case, right? That says that you have the right to marry same sex, and Loving that says that you have the right to marry interracially, and even Roe, which not only talked about the right to marry, but the right to bear children and that kind of thing. Here, the court really found and cited to a case from 1997, Glucksberg, that said that in order for them to decide whether there's a fundamental right here, a due process right, a liberty right, that first they need to describe very carefully what the right is. And then if there is a right, then the protection will only occur if the right is deeply rooted in history and tradition. And so the court defines her liberty interest as a marital right sufficiently important that it cannot unduly burden without procedural due process as to the inadmissibility finding that would block her from residing with her spouse in her country of citizenship. That's a long way of saying you have a right of marriage, but the issue here is whether or not your right of marriage is burdened by the fact that he's not granted his green card. And the court says it is not, that the fact that you are married to him then provided you with the right that you have, which is your right to marry. You had the right to marry him. You are in fact married to him. But for the court to find that the not granting of his green card burdens your marriage goes outside of the scope of the rights that you should be granted, because that right is not rooted in history and tradition, because immigration laws, for the history, I think, of immigration laws, has always been left to the political branch because it concerns issues of national security. And therefore, there is good reason for the government to not, or for the court not to find that this person, Munoz, had a liberty right in her husband's petition. The decision was written by Barrett, and it was joined by, of course, the conservatives on the board, which seemed to have been a trend tonight, Roberts, Thomas, Alito, Kavanaugh. And it was joined by Gorsuch, but Gorsuch, interestingly enough, in his concurrence, really agreed with the dissent in saying, you know what, majority, you could have just ended this case by saying this is not a judicially reviewable issue, period. And therefore, we're sending it back to the Ninth Circuit for them to reverse and let the summary judgment of the district court stand. But instead of doing that, they go that extra step of saying, well, you know what, we're going to find that you really don't have, that U.S. citizens who are married to non-citizens don't have a liberty right in their marriage, so much so that they have an interest in whether or not their husband or spouse is going to ever live with him. And Sotomayor in her dissent, I just want to say one more thing that I thought was interesting that the majority said, is that they said that if they allowed this right, if they allowed this decision to be that it would become a right for a U.S. citizen to have an interest in the admissibility of a non-citizen, that then they would be opening up the floodgates to let every U.S. citizen spouse to go into any court and make any claim with regards to their spouse. And so if a spouse has another spouse who's in a criminal trial, that the spouse who's not in the criminal trial, not the defendant, would have a liberty right or a liberty interest in the spouse's criminal trial. Or a spouse who's a spouse of someone who is in the military would then have a liberty interest in telling the government where that military spouse should be stationed. And so that would become chaotic, and we can't allow that to happen. And the dissent, excuse me, says you went well beyond what this case was about. This case was about whether or not this court has the right to judicially review decisions that are made by the Department of State at the embassy. And the answer to that is no. And it's no because it's rooted on precedent. And they cite to this case Mandel about a Marxist who was going to come speak to a group of law professors. And the law professors sued because the visa petition had been denied on the basis of national security. And the court in that case said, we don't review judicial visa petition decisions, and therefore, this case is dismissed. The court here could have done the same exact thing, but instead they say, well, if you're the spouse of a U.S. citizen, sure, you can be married to that non-citizen, but we don't care whether or not you're going to be able to live with them. That's not a right. You don't have a right to live with them in this country. Go back to their home country and go live with them there if you really wish to live with the court, with a non-citizen. She warns that, Sotomayor warns that this is a slippery slope of watering down marital rights that they said that they would not do in the Dobbs decision. And so it's interesting that really what this case became was an issue of marriage rights more than the issue of immigration rights, because under immigration law and even immigration precedent, this case should have never been decided the way it was. And in fact, it should have ended at, there's no judicial review of a denial of a visa petition, period, we're done, right? But instead, the court waters down this couple's right to be married by saying, yeah, you can be married, but we don't care if you live together. We don't care about your children. We don't care about any of those things. Happy to answer any questions.
Thank you, Debbie, for another depressing summary of the Supreme Court term. It's something we have to live with, though, and work through. We have only a few minutes left for questions. We aren't going to be able to answer all the ones that people have put into the Q&A, but we'll try to get one or two done. If your question isn't answered, we encourage you to send it along to info@riaclu.org, and we'll have somebody respond to your question. The first one, I think we'll be able to get to two. The first one is for Jennifer, dealing with the Grants Pass case. And that is, Rhode Island has a homeless Bill of Rights to protect unhoused people. What effect does this decision have on that law?
Well, sadly, the Bill of Rights for homeless people in Rhode Island has proven to be largely a toothless tiger. It sets forth a theoretical set of rights, but without any meaningful enforcement mechanisms, as Lynette and I learned the hard way when we tried to protect an encampment on First Amendment grounds at the State House, I guess a couple of years ago now. But the effect here is that we were looking to Grants Pass to bolster the rights that are otherwise not very enforceable under the state's Homeless Bill of Rights. And sadly, that is not available after Grants Pass. we would have to make changes here in Rhode Island to the Homeless Bill of Rights in order to make those changes, rather than relying upon what could have become a nationally enforceable precedent if the grants pass decision had not been overturned.
Thank you for that answer. We'll do one last question, and this will be for Jared. You sort of answered this, but we'll give you another chance to see if there's anything else, some ray of hope with the Trump decision. The question is, in light of the broad scope of the court's decision in the Trump case, what realistic limits are left to rein in criminal conduct by a president, and what can be done about it? I know you ultimately said it's sort of a political issue. What are your response to that?
I mean, there's some unrealistic constraints that we have. That is, I think a constitutional amendment is very unrealistic. I think impeachment is very unrealistic. But, not to be too flip about it, I would say the most realistic constraint that we have to prevent and deal with criminality by the president is not to vote for a criminal and not to make a criminal president. Or if we have a president who's committed criminal acts, to vote that person out of office and punish their party. I think that the political process, unfortunately, fortunately or unfortunately, is really the only effective way that we have to go. And that is, deciding carefully who we put into office and doing everything we can to not put criminals into office. I don't know whether that's how satisfying of an answer that is, because it does suggest that there are no legal limits on what a president can do, which is a pretty scary thought. But that, I think is clearly what the court asks us to contemplate. That is, the court clearly recognizes that the president, will have no such legal constraints. The court thinks that that's a good thing, because now the president will do everything that the president thinks is in the interest of the country. But it does mean that the president can literally do whatever he or she wants without any fear, any realistic fear that they're going to ever go to jail for it. So if that's the case, well, what we have to do is make sure not to put criminals in office.
Unfortunately, I think there are a lot of cases this term for which there are no really satisfactory answers, other than to, I think, emphasize the importance of trying to deal with things at the state level, pass some strong state laws to protect civil rights and civil liberties, to provide some sort of bulwark against Supreme Court decisions that are sometimes shredding the federal Constitution. With that, before we wrap up, I just want to say a few things. First, I want to thank the panelists for providing these very great summaries of these important cases. I hope that those of you who attended learned a lot from it. As I said, you should feel free to send any questions that weren't answered to our email, info@riaclu.org. I also want to encourage those of you who care about the work that the ACLU is doing to consider donating to the organization. You can go to our website. You can scan the QR code that's on the screen right now. And we also hope that you'll follow us on social media, at least as long as we cannot be censored, thanks to some Supreme Court decisions. The last thing I want to say is tomorrow, those of you who attended, we'll get a short survey. We ask you to fill it out to tell us what you thought of this event, to give us ideas about how we can make it better in the future. We've done these Supreme Court reviews for a few years now. We've gotten very good reviews thanks to the great panelists we've had. I hope you found it helpful. And I just want to wish you all a good night, and hopefully I'll see you at the next Supreme Court review. Take care, everybody.